Welcome back. The Senate last week amended the Code of Conduct Bureau and Tribunal Act, tinkering with certain sections, especially Section 18, subsection 1 and 2. They transferred the President's regulatory powers over the Bureau and Tribunal to the National Assembly. The Senate also reintroduced a provision which authorizes the CCB to invite anyone found culpable in asset declaration to make necessary correction as against being charged to the tribunal for trial. But there has been argument in some quarters that the Senate, and by extension the National Assembly, cannot make such amendments without first amending the Constitution. Some lawyers react to this issue.
By virtue of the provisions of the Constitution, I think Section 4 thereof, the powers to make laws is vested in the National Assembly. And when I say the National Assembly, it means the Senate and the House of Representatives. Having said that, there is no provision of the law that cannot be amended, including the Constitution itself. I am aware that the CCT is a creation of the Constitution, and if it is a creation of the Constitution, I don't believe it is a law that can be readily amended by just a bill of the National Assembly without following the strict procedures that have been stipulated in the Constitution for amendment of the Constitution, which will include getting, I think, about 2/3 of the House of Assemblies of the states, of all the states of the Federation, to pass a law to amend it. I think that is the position.
You remember in our elementary knowledge of amendments or reading of the bill at the secondary school level that it has to pass through so many stages. Now you cannot just sumo to get up one day and say, look, we want to amend this. You have to go through the constitutional provision in amending it, because our is a written and rigid constitution, unlike unitary constitution where 2 or 3 people can just gather together, or military governments where they operate a decree and 2 or 3 of them can just get up and say, look, we are changing this. It is not like that with Code of Conduct Tribunal. And you know, Code of Conduct Tribunal specifically to curb corruption. That is what it is. And anything that has to do that has to affect the rights of citizens, it has to be properly done.
My opinion is that it's akin to changing the goalpost in the middle of the match, in the middle of a football match. That is what I think it is. They have a right to amend any law, as a matter of fact. The National Assembly is established for that purpose, for making laws and amending laws. However, the Code of Conduct Tribunal Act enjoys a special status by virtue of its incorporation in the 1999 Constitution of the Federal Republic of Nigeria. Yes, it is incorporated by reference. It enjoys the kind of status that the Land Use Act enjoys. So I am of the opinion that it cannot be easily amended without, first of all, amending the Constitution itself.
The President has 2 options. The President has the option of assenting to the bill. The President has the option of not assenting to the bill. In the event that the President does not assent to the bill, of course the Senate, the National Assembly, has the right to veto the President, which is a difficult thing to do. But I think that's democracy. I think that's how it's supposed to be played. But I, as a personal view of mine, I think I would rather side with a National Assembly of many members with divergent views, where arguments can be made for and against certain issues and propositions, than for one man who is the President. Which is not to say, I understand the ideas that people have about the fight against corruption, but I think we stand a better chance of having, it is said that it is at the moment where you have difficulties, if you stay true to your values, then you really have those values as your values. So at this difficult moment, if we uphold the values of democracy, uphold the values of having a parliament and having them to do their job, in spite of the fact that we have corruption, then I think that we are well on the way in making headway with democracy, and ultimately, maybe slow, ultimately our country will be better for it.
And just before we go, let's check out some of the top trending stories from the courts.
We begin with the reports that the National Judicial Council has barred judges who are under investigation for various offences from sitting until the cases against them are concluded. In a statement signed last week Thursday by the NJC's Acting Director of Information, Mr. Soji Oye, the body said it took the decision at its 79th meeting held last week, Wednesday, and concluded on Thursday. The decision appears to be a compromise reached after weeks of resisting calls from various quarters, including the Nigerian Bar Association, to suspend the affected judges or compel them to withdraw from further sitting until they were able to clear their names. A number of judges have been invited for investigation by the Economic and Financial Crimes Commission after the raid of the houses of some judges by the operatives of the Department of State Service on the 7th and 8th of October. With the decision reached by the NJC on Thursday, the affected judges will no longer conduct proceedings until the cases against them are concluded. The President of the Court of Appeal, Justice Zainab Bukachua, last week constituted a fresh panel to hear the appeals emanating from the disputes on the governorship ticket of the People's Democratic Party for the November 26th governorship election in Ondo State. The new three-man panel is led by Justice Ibrahim Saulawa of the Calabar Division of the Appeal Court. The two other members are Justices Ignatius Agube and Ita Mbaba, both from the Owerri Division of the Appellate Court. 3 of the 5 pending cases on the matter has been assigned to the new panel. The fresh panel was constituted to take over the cases following last week Tuesday's decision by Justice Jumai Sankei's panel, disqualifying itself from further presiding over the cases. The panel gave as its reason for withdrawing from the cases a petition filed by a respondent in some of the cases, Mr. B. Boroye, accusing the panel members and Justice Bukachua of having been bribed to rule in favor of one of the candidates. The Economic and Financial Crimes Commission last week Monday rearraigned a former governor of Abia State, Orji Kalu, before a federal high court in Lagos for an alleged fraud of 2.7 billion naira. Mr. Kalu was rearraigned alongside 2 others on 34 counts of money laundering before Justice Mohammed Idris. Their rearraignment followed the transfer of their case from the Abuja division of the Federal High Court to the Lagos division. They had earlier been arraigned in September before Justice Anwuri Chikere of the Abuja division of the court. But the Chief Judge of the Federal High Court, Justice Ibrahim Auta, subsequently transferred the case to Lagos, a move which was rejected by the defendants. In the charges, the defendants were alleged to have siphoned Abia State government funds totaling over 2.7 billion naira while Orji Kalu was governor of the state. Staying in Lagos State, Justice Babs Kewumi, also of the Federal High Court, has refused to order the forfeiture of the $15.5 million found in the accounts of companies belonging to Warikpamo Dudafa, a former special advisor on domestic affairs to former President Goodluck Jonathan. Justice Kewumi convicted the companies after a review of the facts of the case presented by the Economic and Financial Crimes Commission. The companies had on September 15 pleaded guilty to laundering $15.5 million when they were arraigned. After the court convicted the companies, the EFCC urged the court to order the forfeiture of the money to the federal government. But the judge said he would hand over a sentence on the companies after the trial of the others who pleaded not guilty in the charge, especially as the ownership of the monies is still in dispute. Wife of former President Goodluck Jonathan, Patience, had laid claims to the monies in the company's accounts, insisting it was hers. And we round up with a report that the British High Court last week Thursday ruled that the British government cannot start the process of leaving the EU without the approval of Parliament in a landmark judgment that could delay Brexit. 3 senior judges said Prime Minister Theresa May's government does not have the power itself to trigger Article 50 of the EU's Lisbon Treaty, the formal notification of Britain's intention to leave the bloc. The Prime Minister's office has, however, said that it is disappointed at the decision and would appeal. The case is now expected to be heard in the Supreme Court in early December.
And that's the program for today. Don't forget that you can find these and past episodes of the program on our YouTube page. I'm Shola Sheyeli. Thank you for watching.